Okay, good morning. Today is here with us Professor Michael Moore. Michael Moore is professor at the University of Illinois in the USA and is a well-known author in this context and in this group. So there is no need for a complex and large presentation, but Slowly is professor in University of Illinois. His works are mainly in the philosophy of criminal law and also in moral philosophy, etc. And this last year he published this I think excellent book, Causation and Responsibility, that a great number of us studied in a seminar on causation, the precedent academic course, and this is the first of two seminars, of a couple of seminars. The session for today is on moral act, and the session for tomorrow is about torts and causation in Anglo-American tort law. I would to agree, especially to Michael Moore, his visit to our university and his disponibility for the discussion with us. That is very, very important for us. Thank you very much.
Thank you, George. It's a pleasure to be here and to have the chance to talk about one of my favorite subjects, which is causation. I will talk about tort law tomorrow, which is a different part of the book. I did give Jordi some outlines because since my Spanish is non-existent, I will be talking in English, and you might find it helpful to see what you might call the libretto of the opera in front of you while you're listening. So if you have an outline, that's pretty much what I want to do. As Jordi said, two different topics. Today is really a topic in moral philosophy, which is part one of the causation book, about whether or not results matter in terms of making us more blameworthy morally than we would be for simply trying or risking a certain harm. Tomorrow I want to talk about causation on a more strictly legal plane, and that's the role of causation in American, Anglo-American tort law, and the role it should play and the role it does play. So if this is too much philosophy for you, tomorrow you might like better, and tomorrow might be too much law if you like moral philosophy. The book. I don't see too many copies around, but at 75 English pounds for the hardcover edition, that doesn't surprise me. The good news is Oxford's like other publishers. They understand enough economics. We were having coffee next door at the economics coffee shop to understand the inelastic demand curve of world libraries for books, because they can't not buy certain books with certain titles. So once they exhaust the library publishing, which they have, which pays all of the publishing costs, then they release the paperback. So if you're waiting, the paperback will be out in August with the same covers and the same content and a significantly cheaper price. They're actually reissuing two related books, Placing Blame, which is even more expensive, in hardcover, and Act and Crime. They have the three and identical covers in paper coming out in August. So if you are looking for Christmas presents next Christmas, box sets of these will be available. Okay. I told Jordi that we would do perhaps chapters 2 and 3 of part 1. The outline I handed out is really just chapter 2, the issue of moral luck as it's usually called. If we have a chance, we might get a chance to talk about the issue in chapter 3. Here's the way the two chapters relate to each other. Chapter 2 deals with degrees of blameworthiness. Does it make you more blameworthy if you cause a harm that you unreasonably risk or predictively believe that you're going to cause, or that you intend to cause, does it make you more blameworthy to cause what you risk or intend than simply to risk or intend it when you don't cause it? That's often put in moral philosophy as the issue of moral luck, and one of the things I want to talk about is whether that's the right way to put it. The issue in Chapter 3 is different. It deals not with degrees of culpability or blameworthiness, but with degrees of permissibility. It's what I was saying to one of you 2 days ago about weak permissions. It's a question of whether or not you can justify prima facie evil and prohibited actions with good enough consequences. And a weak permission is what entitles you, in my definition of that phrase, entitles you to justify with good consequences. So in Chapter 3, for example, it's often distinguished in the ethical literature of the last 40 years between the surgeon who cannot, it is said, categorically cannot cut out all of the organs of a perfectly healthy patient to give each organ to somebody else who will otherwise die without it, so that even if he would save 5 by killing 1, he's not permitted to justify that action. Whereas in the proverbial trolley case, beginning with Philippa Foot at Oxford in 1968, where the trolley is running down the track in the familiar example and will run over 5 people unless you turn it onto another track where 1 person is trapped. If you turn it, it will kill 1 rather than 5. Many people think you are permitted to justify the turning of the trolley to save 5 lives, even though it will take 1. And the question in Chapter 3 is, what's the difference between those kinds of cases? What makes it the case you're permitted to turn the trolley but not cut out the organs in the surgeon kind of case? There's 2 general sorts of answers, one of which I go through, the doctrine of double effect, in terms of intending versus foreseeing a certain harm. But that's really the warm-up for the chapter. The chapter is really about the second 1,000-year-old Catholic doctrine, the doctrine of doing and allowing. And it's not just a bit of Catholic theology. I think it's built into most legal systems to draw these distinctions. And what I do in Chapter 3 is give 6 versions of the doctrine of doing and allowing, all of which turn on causation, to show that causation not only increases blameworthiness, but it also marks the border of permissible consequentialist calculation. So it has 2 roles in ethics, one of culpability measurement and one of permissibility. If we get a chance, maybe we can talk a bit about the second. That's also true of, incidentally, intention has 2 sorts of roles. It's often thought it makes you more blameworthy to intend rather than simply foresee a consequence. And under the doctrine of double effect, it makes it permissible to justify with good consequences what you only foresee but not what you intend, according to this 1,000-year-old doctrine. In any event, if we get a chance to talk about it, that would be fun. I kind of doubt that we will. That's my predictive belief. And I don't have an intention one way or the other on that. Okay, here's how I'd like to do it. There's a lot of stuff that we could talk about in Chapter 2. The outline that I included has page numbers. The 200 series of pages refers to the earlier chapter in Placing Blame from which this discussion is taken. The 20-something paginations refer to the pages in this book in Chapter 2. As I say in this book, it builds on the earlier discussion, so basically I feel free to incorporate both chapters in my discussion of the issue. So what I'd like to do as a format is work through a series of topics in roughly 3 different clumps. And Jordy said I should talk for, 2 to 3 hours, I think, and then we'll have a discussion. Is that what you want to do? No, he's not listening. So I will talk for a bit on a particular topic, and then I think we can stop for a discussion. It will tend to focus the discussion better than if I simply talk for 40 minutes to whatever. And then we have questions. So if that's all right, I will talk for a while and then see what you think. And then I'll talk for a while and see what you think about that. It does tend to keep the discussion more focused. So with your permission, let me start then down through this outline, which I had, I guess, distributed by email. So first question actually isn't the first question on the outline because I changed my mind. First question in the book in Chapter 2. Yeah. I thought maybe you wanted me to stop and we could talk about your organization. Is the legal setting. I didn't include chapter 1 of the book. Chapter 1 basically says what the outline says under what I have down here is question 2, the institutional importance of the issue. Namely, that Anglo-American criminal law and the law of torts is causation drenched in its liability rules. That is, that causation plays a significant role. Now, this is just a descriptive thesis about the doctrines that we have. In criminal law, for example, homicide is defined sometimes, like the American Law Institute's model penal code, as causing the death of a human being, in which event causing is up front and center as an element of liability. More typical are statutes which define things like homicide as killing a human being. They use what linguists have called causative verbs of action, verbs that have built into their semantics, into their truth conditions, the causing of a certain state of affairs. In the case of killing, it's death. In the case of the crime of mayhem, it's disfigurement, which means loss of an eye, loss of a limb. In the case of battery, it's causing contact. In the case of a definition of an assault, it's often causing apprehension of imminent contact and the like. So throughout the liability rules of criminal law, explicitly or implicitly, causation is an element. It's also the case that causation plays a role not just in the liability rules, but in also the sanction. So that in a typical American criminal code, completed crimes, crimes where you cause the harm the law cares about, are punished at twice the rate of inchoate crimes, crimes where you don't cause the harm, you simply try to. You intend it, but you don't succeed. California Penal Code, for example, puts that at a 2-to-1 ratio. The old common law of England actually had it at a higher ratio. Attempts were punished simply as misdemeanors, whereas the completed crime was typically punished by death. So it made a huge difference in the English common law as to whether or not you caused the harm that you either tried to cause or unreasonably risked causing. Tort law is, I think, the same structure. Sometimes you get explicit uses of causation, such as in the law of negligence. When you teach torts in America, you always teach your students 4 elements of negligence, right? Duty, breach, which is unreasonable negligence. Causation and damages. It's an explicit element of the cause of action that has to be pled and proven in every civil case of negligence in America. The same is true for strict liability, which even emphasizes causation more because it's causing harm, even if you didn't intend to, that can make you liable for keeping wild animals, products, a few other pockets of strict liability. For intentional torts, the causal requirements are implicit, just as they are in criminal law, because intentional torts, such as confining, that's to cause a confinement, or wrongful death, of course, to cause a death, killing, or battery to cause a contact, or assault to cause apprehension of imminent contact, it's equally causal. It's just implicit as it is in the causatives, the use of causatives in American criminal law. So the law we have in torts and criminal law is drenched in using causation as both the touchstone of liability and the degree of punishability in criminal law. There's even some argument, there's a remedy-based use of causation in tort law. Depends on how you read the restatement of torts, second and third, with regard to apportioning damages based not just on comparative fault, but also on comparative degrees of causal contribution. That would also be to use causation as fixing the amount of the remedy and not simply the liability to start with. If you had regimes that eliminated this use of causation in criminal law and torts, what would they look like is an often asked question. Joel Feinberg, the well-known social philosopher in America, for his retirement dinner, he waited till the end of his career to address this question of does causation matter. This was in 1995. His friends went down to Tucson. We all sat and celebrated him. He started out saying, you know, legal philosophers at some point have to deal with the issue of whether causation matters to blameworthiness. And he says, I haven't done it my whole life. Now I'm going to do it in my last paper. So he gave a paper on why results, he thought, didn't matter, and why the criminal law, therefore, has to be radically redrawn. At the very least, you do what the American Model Penal Code does. You punish inchoate crimes as severely as completed crimes, because causation doesn't make any difference on this view. Causation doesn't matter to blameworthiness, and therefore you punish attempts just as much as completed crimes. And with regard to risking, the same result. Reckless endangerment should be punished as much as manslaughter, because the fortuity of causing a result unreasonably risked shouldn't make any kind of difference on this view. More radically, there's a recent book that Cambridge University Press just published by two of my colleagues and one of my former students, who apparently listened to me carefully enough over all these years to put knots in front of my sentence and call it their own book. This book defends the view that you should radically rewrite criminal law to eliminate causation out of the liability rules entirely. They depict accurately what, if you settle the issue we're about to discuss differently than I would like to settle it, you should not only change the punishment scheme, you should radically change what liability rules look like. Causation would drop out as an element, and intent, predictive belief, and unreasonable risk would be the sole touchstones for criminal liability. Those kind of schemes are also not unknown in tort law. If you take causation out of tort law and take the view that risking harm unreasonably or asymmetrically, as George Fletcher used to say, if that's the touchstone of both doing wrong as a defendant and of being wronged as a victim, if that's the touchstone of wrongdoing, risking rather than causing, then you ought to have a very different looking tort law. Then you ought to have a tort law that has a risk tax or a risk payment. Every time someone unreasonably risks, you should contribute to the fund. Every time someone is unreasonably risked, you could recover from the fund. Causation would then be used at most as a proxy for when it's the case that money actually changes hands. You might think it's too hard, as Calabrese says in The Cost of Accidents, a famous book. It's too hard to measure risk. We'll simply pay for when you cause harm, but the reason you pay isn't that you caused it. The reason you pay is that you unreasonably risked it. And for repetitive activities, it's a pretty good proxy. When you cause it, you'll pay for all the unreasonable risks you did when you didn't cause it. And the same for recovery. You'll recover when you're caused injury, not because that entitles you specifically to recovery, but because it's administratively convenient. We'll let you recover, and if it's enough times that people repeat, the recoveries for caused harm will equal the recoveries they should have for risked harm. But the rationale would be risk, not causation. Short answer, chapter 1. The regimes we have in law would be very different in torts and criminal law if you take seriously the view that blameworthiness does not depend on causation. Thus the book, chapter 2. It does depend on causation, so we should have the law that we do have as its thesis. It may puzzle you a bit to think that I can move so quickly from morality to law. Chapter 2's issue is an issue in moral theory from which I derive legal conclusions. But there is a hidden premise. It's a premise defended in other books, mentioned here, but not defended. The premise is simply this. Both the law that we have and the law that we ought to have in torts and criminal law depends, at least in part, on moral blameworthiness. That you should punish only if someone is blameworthy, that you should pay tort damages only if morally you have a duty to correct the injustice that you have unreasonably caused. That's not an uncontroversial thesis. Be happy to defend it, but it's not a part of this book to defend it. It's part of Placing Blame and other books defending the retributive theory of punishment, corrective justice theory of torts, and the like. So if you notice some slippage, it's because undefended is the connecting premise. If someone is not morally blameworthy, or not more morally blameworthy, the argument is legal liability should follow those moral conclusions. Separate point. Okay, here's the first issue on the outline that I want to talk about, and then I'm going to stop for a bit. First issue on the outline is this one. It's usually called, this issue we're talking about, the issue of moral luck. That came about because of Tom Nagel and Bernard Williams in 1976 exchanging two articles, each of which were called Moral Luck, two well-known English-speaking philosophers. And the argument was, you're morally lucky if you don't cause the harm you're trying to cause, because usually causation, failure or success, is due at least in part to factors over which you had no control. And yet blameworthiness is thought to depend on the traditional view of morality on causation. And thus the conclusion, if you think blameworthiness depends on causation, and yet you really don't control what you cause, then it must be there's such a thing as moral luck. You are blameworthy for things over which you had no control that are just a matter of luck. Now that's the way Nagel and Williams both framed the issue, even though both of them actually argued there is a kind of moral luck. Namely, they thought causation does matter to moral blameworthiness. Despite thinking that, they framed the issue in the way, as I put it in the book, is least sympathetic to their conclusion. They put the issue as being one of whether or not moral luck exists, whether or not, contrary to what Kant said, you can be blamed for things over which you do not have control. Sounds unfair, sounds disproportionate, and Kantians, dealing with ethical, not juridical duties, would think it's outrageous to be blamed for things over which you have no control. Now the first issue is simply, is that the right framing of the issue? I don't know what either the Spanish or the Italian, let alone the Catalan, speech would be with regard to the word luck. In English, this is literally a misuse of the word luck. The word luck in English divides the accidental, the freakish, the unforeseeable and the unintended on the one hand, from all the things that you do intend, you do foresee, that are not freakish, that are ordinary, normal, and foreseeable. The normal use of luck in English is something like this. I'm a terrible archer, bow and arrow. If I were to try and hit a target at 100 paces, the old English archery contests, and I actually hit the bullseye, that would be lucky, because I couldn't do it again. It would surprise me and surprise anybody who knew my level of skill. If the proverbial English bandit, Robin Hood, hit the bullseye, you wouldn't say it was lucky. That was what not only he was trying to do, but over which, compared to me, he had relatively good control. Not complete control, but pretty good control. What's lucky, what ought to be the baseline by which you measure luck, is the degree to which something that isn't something you mostly control comes about. Now, on this notion of moral luck would exist if and only if you were held responsible and more blameworthy for items that were freakish, abnormal, unforeseeable, and came about through absolute items that are a surprise to you. But of course the law, like ordinary speech, does not attribute responsibility. We use notions of proximate causation, which is what I'm going to talk about tomorrow, to divide off things that are due to luck from things that are due to skill. And the law we have and the morality on which it's based actually blames people only for things that are in the normal course, the expectable results of their action. The freakish and the like, the things that would be unlucky of you to be blamed for, we don't blame you for. In which event, that isn't the issue. The issue is not one of moral luck, because morality and the law built on it does not blame you for luck. It blames you for the things that in the ordinary sense of luck are not due to luck. They're due to your control. Think of it this way. I want to kill you. I have a gun. I put the gun at your head and I blow your brains out and you die. Is there any luck involved? In the ordinary sense of luck, there's no luck involved. That's exactly what I was trying to do in a competent way, and that's what I did. In the sense of Tom Nagel, Bernard Williams, and the philosophic tradition that followed them, there was luck involved because, Tom Nagel's example, even though the gun is right here, a large bird could have somehow swept into the room and got between me and Geordie and taken the bullet. That it didn't do so was a factor over which I have no control. Therefore, it's a matter of luck whether or not I succeed in killing it. Well, not in the ordinary sense of luck, only in an artificial sense in philosophy. So what I try to do early on in this chapter, and at greater length in the earlier chapter from which it's taken, is reframe the issue. It's not a question of moral luck. It's not a question of whether moral luck exists. In the ordinary sense of luck, our moral judgments and the law built on them doesn't presuppose it does. It's only in the extraordinary sense of luck does moral luck exist. I'd kind of like to see what you think of the reframing. Let me just say one more thing. Reframing an issue does not get rid of it. That it's not an issue of moral luck doesn't mean it's not an issue. The issue can be simply stated. Should you be blamed more for causing results than for simply risking them or trying? That issue is perfectly easily stated with no misuse of the language. So that I reframe the issue from moral luck, there's a reason I want to do that, which you'll see in a moment. It's not neutral, but it nonetheless doesn't get rid of the issue. Some people think in the old ordinary language style of philosophy of Oxford of the 60s that if you can reframe issues, you often get rid of them. That might have been true, but that's not the case here. Reframing it may make it more accurate, but it doesn't get rid of it. So I guess I'm curious whether or not you find persuasive the misuse of the word luck. Or if you want to talk about the institutional implications, I'd be curious about that too. And then perhaps we get on to the substance of the argument. So let me stop for a minute while I get a drink.
Okay. Discussion then is open for this part of the presentation. Andy?
So I've never studied this question of moral luck. Always had it on the periphery somewhere, but I always thought that the person who was morally lucky was the one that was actually hit by the bird, because it was the bird that kept him from being electrocuted or something like that. So maybe I got it wrong, but the way you presented it does not make sense at all. You're right. That isn't the other way.
Yeah, I know you Australians don't often get credit for this, but your English is perfect on this one. Namely, if you're the victim and the bird saves you, which is miraculous, right? That in ordinary speech would indeed be very lucky. But now make the reverse situation, which I think you see. There is no bird and it doesn't save you.
Right.
Is it the case I am morally unlucky because there was a factor over which I had no control that was necessary not to occur in order for me to do what I intended to do, which is shoot you? So your use of the bird makes you lucky is perfectly idiomatic English. The non-existence of the bird making me morally unlucky I find not idiomatic English, but I gather you agree with that.
I would agree with that. I think between lucky and unlucky there's some logical space.
Well, that actually isn't it. It's you have to see that if the bird actually flies in between, that there really is luck, because that's just a wildly odd thing to happen. But if it doesn't fly, there's nothing that turns on the positive negative here. It just turns that the rare event is that it does happen. That it doesn't happen is the non-rare event, in which event it's inappropriate to speak of luck, because that's how the world operates. So it's not a question of positive negative. It's not lucky unlucky. It's here the case that the thing that is expected is there is no bird, in which event if I succeed, it's odd to talk about luck. But of course, the issue framed as moral luck makes us say, well, you were just morally lucky in the sense that, or unlucky, you were blamed for something over which you had no control. Here's the payoff. Notice control is as unidiomatic used this way as luck. If I put a gun to your head, check the bullets, make sure they're all there, intend to kill you, and shoot you to death with it, did I control your death? Does the fact that a bird could have flown between my bullet and your head, in any sense of the word control, mean I didn't control your death? It does mean there were factors, the absence of which were necessary for the death to occur, over which I had no control. That's true. But ordinarily, when you speak of control, you don't mean you control all the possible preventers of the harms you're trying to cause. You simply mean you have a reasonable chance of success, and you control the variables that give you that chance. So control will follow luck in this sense. In the ordinary idiomatic sense of English, I am in control of your death when I take the precautions that I do and shoot you dead, and I'm not morally unlucky because I'm not blamed for something that I don't control. It's only semantics. It doesn't get rid of the issue, but I do think it levels the playing field. Otherwise, you end up having to say with Kant, boy, isn't it amazing, isn't it astonishing that morality blames you for things you can't control. I don't want to say that.
Maybe the example is not a good example to make the argument, this example with the verb. But put the example of an extraordinary surgeon, an extraordinary doctor. Okay? You fire a gun, and the gun hits the victim, and a normal doctor couldn't save the victim because he was a mortal wound.
Right.
You got the leg, and you go to an hospital with an extraordinary surgeon, and this extraordinary surgeon saves you. This is not you were very lucky. You were still make the distinction. If the extraordinary surgeon saves you, you are still punished only for and not an attempt for an attempted murder, not for an attempted murder. If you make this, I would say, okay, there is a point in moral life. There is a point. In one point, you can say luck draws the line between attempted murder or murder.
Yeah, it does. In the case in which you get this incredible surgeon who puts the brain back together, right? He's studied enough neuroscience, he literally can put together what no other doctor could put together. Idiomatically, you were very lucky as a victim. But now, what's the moral luck involved for the defendant? If there were no such surgeon, Nagel and Williams and the philosophers want to say, well, then you get blamed for causing the death of this person who wasn't saved by the extraordinary surgeon who wasn't there, and that's morally unlucky for you. But of course, in the ordinary sense of luck, it's not unlucky. There's only one such surgeon in the world, and that you didn't get him was hardly expected. So again, notice what I've done. I've reversed the valence of your example. You're using luck idiomatically, as we did before, and then the flip side for the philosophers is to use it unidiomatically by saying, well, the absence of such a surgeon, that would be morally unlucky because you would be blamed for causing a death that was only due in part to factors over which you had no control. Namely, that extraordinary surgeon got involved in an accident and didn't make it in time to save you. So again, I think your use is idiomatic. The use I'm complaining against is not. And you can see it in your example too.
I have two general questions about the subject of moral law. And I would like to know if you think that there is any difference in the case in which we talk about moral luck when some bad result is the result and there were no bad intentions, there were no, for instance, there were no bad intentions or there were not bad action.
Yeah.
And, or in the other case in which there are no bad results, but there is a bad intention, and then we could still talk about luck because of that, and the general question about there is asymmetry or symmetry in the kind of moral luck. And then I also would like to know well, I'll ask you the next question later.
Yeah. Well, you posed the question of examples. The pair of examples is culpability, intention, without causing it, and causing it without culpability. Now, I didn't say this, but it's important to see those are actually not symmetrical examples the way the morality and the law built on it regards them. If you have your first example, causing of a harm without it being the object of an intention, or even the object of a belief, a predictive belief, or even the object of an unreasonable risk. So you risk not culpable with respect to that harm. Causation doesn't make you blameworthy. Causation, unlike intention, is not an independent determiner. In that sense, causation is the poor relation of intention and other states of culpability. It's only if the harm you cause is an instance of the type of harm you culpably intended, foresaw, or unreasonably risked that causation does its moral work. I didn't say that because it's complicated. The relationship of causation to blameworthiness is more complicated than it is for intention. It's dependent on intention in a way that intention is not dependent on causation. So there is that asymmetry in the two pairs of examples that you give. Now you tied it to luck, saying, well, if you tried to cause a harm and didn't, you're kind of lucky, aren't you? Well, it depends on why it didn't happen, but it could be the case that you are lucky, but you're not morally lucky in the sense that you're not being blamed for something that depended on luck. You're not being blamed for something that might have depended on luck if it happened on these people's view. But notice in the case in which the harm doesn't happen, but you tried to bring it about, well, you are blamed, but you're not blamed for anything that you're not blameworthy. Namely, you're blamed for your intention, and there's nothing on this view that says that's a matter of moral luck. It's ordinary idiomatic luck for you that you didn't cause the harm you were trying to. That's not the sense of luck of the philosophers. Right? Now you had a second part of your question. Okay. I think there's plenty, there's more meat on the other bones, so I'd just soon go on if that's okay. As I said, you can agree with everything I've said so far, and the issue has not been prejudged one way or the other. It is now an evenly balanced question. Does causation of a harm that you intended or risked make you more blameworthy and thus liable to sanctions in tort and the criminal law in the way that I described? That's an open question. I haven't made an argument one way or the other. Reframing the issue does not answer it. It simply frames it, I think, in a fairer way. So, in what's called question 3 of the outline, I go through, how many arguments are there? 12 arguments that are all dreadful arguments. They're all arguments in the history of philosophy of the last 50 years, arguing for my position. So I would like to like the arguments, I just don't like them. Joel Feinberg, in his summary in 1995 at his retirement dinner, did the same thing. He adopted my taxonomy, went through the arguments, and said, they're not just bad, they're surprisingly bad. They're dreadful. So I don't want to go through all of those. I don't in this chapter. I do in the earlier book from which this is taken. So unless you find any of these that you really like David Lewis's penal lottery, there's lots of cleverness in these arguments, but there's absolutely, as far as I'm concerned, nothing correct in any of them. They go no distance to establishing the conclusion I want to establish. So I put those all aside and said, well, that's no help. What I've noticed is that my opponents, who think that causation doesn't matter to moral blameworthiness, are not nearly so charitable. They think they have an argument that the persons on my side of the street don't have. So that's part B over on the next page of this outline, called the argument from control. John Elster was my commentator at Columbia in New York City a few years ago on this topic, and I noticed Elster thought that he had an argument, and he kept saying, you Moore, you're just relying on naked intuition. So see if Elster has an argument that I don't have. Here's the argument for control. I stated in simple form in the outline, namely, you can be morally responsible for anything, including the results of your actions, only if you're in control of them. Right? First premise. Second premise, you don't have control over results, because birds can fly between your bullets and their intended victim, for example. And conclusion, therefore, you're not responsible for results. A simple sort of argument for control. The intuition, if you don't take it formally, the intuition is pretty simple. The argument is you control what's in your head. You control your intentions. You're fully in control of your intentions and even your execution of those intentions into the willings of discrete bodily movements by which you execute those intentions, and maybe even the bodily movements that those willings both have as their object and cause. You're in control of all of that, the argument is. You're not in control once the causal chain breaks the skin. Once the bodily movements have to cause results in the real world, like contact with people, or frightening of people, or confining of people, or death of people, those results are not within your control because of all the factors that you can't control that might intervene and prevent those harms from occurring. So the intuition is that you're in control of what's inside and you're not in control of what's outside. All right? That's the argument, which I've heard now for a very long time. What I do in the chapter is say I think there are three versions of this argument. The version as I've stated it is fallacious because it equivocates on control. It gets all of its plausibility in using control in two different senses in its two premises. In the first premise, when you say morality does not blame you for things you don't control, you mean control in the ordinary idiomatic sense of control. You are not in control of the weather that destroyed Port-au-Prince in Haiti, right? We just can't control that stuff. Therefore, you can't blame me for what happened to all those people in Haiti is a perfectly plausible thing to think, in a perfectly plausible sense of control. The second premise, however, says we don't control the intended results of our action. Yeah, we do. In that sense of control, we do. In the sense of control, if I put a gun at your head intending to kill you, pull the trigger, and I'm due to kill you, even though the possibility of the gun being unloaded, the firing pin being missing, the bullet being a dud, a bird flying between me and the bullet, the possibilities of preventers is endless. And I don't control that they're absent. Nonetheless, I control enough of what makes possible the death I intend, that in the ordinary sense of control, I'm in control. I am in control of the death in a way I'm not in control of what happened in Port-au-Prince, the weather. Therefore, if you take control in two different senses, you end up with a fallacious conclusion that you use the same symbol, of course, given that it has a different reference, does not give you a valid deduction. So it can't be that the argument goes through under two different senses of control. My example in the chapter is from an old jurisprudence text from which I used to teach, dealing with ambiguity in natural languages. As I recall, the example is every foot has 12 inches. This foot, this is a foot, referring to someone's lower extremity. Therefore, his foot has 12 inches. Is fallacious because foot is used in two different senses, right? The same is true about control, although it's not as easily seen. So, two valid forms of the argument where the only question then is the truth of the premises. If control is ambiguous, then use it, as the linguists say, univocally. Use it in one sense or the other, and the argument at least is a valid deduction. Whether the premises are true is a different question. So take control in the extraordinary sense of the philosophers. You're only in control of something if you control all the factors that might have prevented it. Well, in that event, the second premise is true. You're not in control of the results of your action in the sense that you do not control the wild birds and all the other unseemly things that might happen to prevent the harm that you intend. In that sense, you're not in control, quite right. But the first premise is surely false. The first premise is that moral responsibility, blameworthiness, depends on you having complete control of all the factors that might have prevented and harmed that you intended. Surely that's not the case. Surely you're responsible even though you don't have that kind of control. Or, if you take it the other way, if you say, well, no, if that's the kind of control you need, you can also do a reductio on this position. Well, in that sense of control, you don't control your own intentions. You don't control the bodily movements that execute them. You don't control the motives behind those intentions. You don't control anything in that sense. So if control were necessary for responsibility, in that stance, the first premise, then nobody's responsible for anything is the absurd conclusion. What I did in an earlier book is say, look, the etiology of action on a standard account of practical reason looks like this. Here are the results in the real world. And I guess in my outline at the end I put some numbers on these things. Let's call these the relations. They go like this. 6 relations between 7 and 11. The results in the real world are surely partly the effects, I didn't have room to write it, that's a B and an M, of the bodily movements that your intentions cause. Your bodily movements, say of pulling the bullet on a gun, causes the death of a person, but not by itself. Right? It's certainly not just that. It also requires a lot of other things that you do not control to either be present or absent in order for that bullet to cause the death that it does. He has to not be wearing a bulletproof shield, the bird doesn't have to fly through, and all of that. All of these things you don't control, absolutely right. It causes the results, but not by itself, because factors over which you have no control also have to contribute. But notice that's true all the way up this chain. Of all the things people in the history of Western philosophy have said are the desert bases for moral blame, it's always the case. There are factors that you do not control. So take whether or not the willing of a movement issues in fact the movement will. Does it cause it? Well, if indeed you're like most of us most of the time, that's true. The willing causes the bodily movement, but that's also due to factors over which you have no control. It does depend that Tom Nagel's not here holding down your finger, for example. You can't control Tom, but he has to not be doing that in order for your volitions to cause your bodily movement. Do your intentions issue in your volitions? Well, that's also due to factors over which you have no control. Neuroscientists these days, it's one of my hobbies for the McCarthy Foundation in America, is doing the neuroscience of this stuff. The intentions look like they're up in the precuneus. The volitions are down in the supplementary motor area. If your connections aren't any good, you can't control that, and it happens sporadically. It just turns out this message gets lost, and you can't control whether your intentions in that sense cause your volitions, because other factors over which you had no control have to contribute for this to be a success. It's also true about whether you form an intention. Suppose you have a motive, a belief desire set on standard philosophy of action, a belief desire set of a certain form Aristotle called a practical syllogism. You want to inherit money from your old uncle. You believe if you kill him, you'll get the money. You therefore formed the intention to kill him. You therefore executed a volition, which leads to a positive movement, which leads to his death if everything works out. But between here and here, you could have the desire to kill him, the belief, the desire to get his money, the belief that if you kill him, you'll get the money. And yet, as Joel Feinberg says, you might have a sneezing fit that makes you forget that you so want to kill him, and therefore you don't form the intention. Or you never get the opportunity. He always evades you where you could ever kill him. You can't control either the sneezing fit or the opportunity that governs whether you have this intention as much as whether you have these belief desire sets. But suppose you're not a Kantian where you think the desert basis is intention. Suppose you're an Aristotelian. It's with character. Well, of course, you don't control your character either. Even if with Aristotle you think you have these existential moments where you choose your character, there are certainly factors like genetics and environment over which you have no control that give you the character that you do. And whether your character issues in particular belief desire sets also depends on opportunities over which you have no control. So, answer. If you need this kind of control, for responsibility, the first premise of this argument, then no one's responsible for anything because no one has control over any of the desert bases that are supposed to be the desert bases for responsibility. I find that quite damning for taking control in this extraordinary sense. Remember I said there's three forms of the argument. One equivocates on control, that's just a fallacy, invalid deduction. One uses control in this stringent sense. It's implausible in the truth of the first premise because then it makes nobody responsible for anything. The third possibility is this one. Use control in the ordinary idiomatic English sense. Namely, you're in control of some result if and only if you can rule out a reasonable set of expected preventers, but not all of them. It's vague, but so are many things in life that are quite useful. You don't have to be able to rule out everything to be in control in this sense. I call this the compatibilist sense of control after the compatibilism debate about free will. So suppose you use control univocally in that sense. Then the first premise looks true. Namely, you're responsible only for things over which you have some control in this sense. Namely, control that will allow you to rule out some factors that prevent. It allows you, in other words, to get what you want in the world. We do need control like that to be responsible. That looks plausible. But now the second premise. Do you not have control of results? That just looks false. In that sense of control, you have control of the results that you intend when you carefully select the gun, carefully make sure the bullets are working, make sure the gun's in good firing position, get yourself in a position where the person's going to be. You pull the trigger right next to his head. That looks like you've got control in the ordinary sense of the word. So the second premise of the argument then looks false. Now that is, as I say in the outline and in the book, is where issue is joined between me and my friends, including my former students. It's one of the delights of being a professor, right? No student worth his or her salt ever agrees with you. They always have to write books going the other way. So take this new book that's just out from Cambridge by Kim Frazan, Mary Alexander, and Stephen Morse. They want to say, okay, use control in Moore's compatibilist sense, the idiomatic sense, the non-stringent sense that everybody thinks they mean when they talk about control. You still have more control of what's in your head than the results in the real world. Now notice, that almost gives away the game for them, because more control won't cut it for them. That makes it a more or less matter, and what they've got to defend is a bright line. They've got to say, you can be blamed for your intentions, and in fact, their desert basis goes something like this. They're not Aristotelians, they're not even Aristotelians to here, they're Kantians of this form. Their idea of a desert basis is from relations 4 and 5. That's what makes you responsible. What their book defends is this. You're morally blameworthy for the intentions you form, the volitions or willings that issue from them, and the bodily movements that are the objects and the effects of those willings. That's your desert basis. In a nutshell, you're responsible for executed intentions, or as Alexander calls it, completed attempts. That's the desert basis they think makes you responsible, and they say you're in control of this stuff in a way you're not in control of results in the real world, as a matter of degree. The answer number one is matters of degree won't cut it. They need to say, well, you are in control here and thus are blameworthy, and you're not in control here and are not blameworthy. That is not a matter of degree, that is a matter of yes and no. But what they think is the difference, it should be something like, you're more blameworthy for this than for this, but you're blameworthy for both, is what follows from the degree difference they allege between the amount of control. The second point is this. Is it factually true? In the ordinary sense of control, do you have more control about whether you get a chance to form an intention, whether all the equipment is working so that you can form the willing, whether indeed your arm isn't being held down, paralyzed, or in some other way incapacitated so that the arm movement will, in fact, occurs? You have more control of these two relations than of that one. I don't know, compare some cases. Go back to the gun at the head. I put a gun at your head, pull the trigger. I don't control all the factors, but that's not the sense of control we're using. I control a lot of factors that make it 99-point-something% probable I'm going to kill you. Try wiggling your ears. I can do it this way. I don't mean that way. Will your ears to wiggle. How's it going? What's the relationship, number 5, the likelihood of success? We know it's in what philosophers call the basic act repertoire of people. You do have, in a deep sense, the capacity to wiggle your ears. It takes a lot of training to get there. If you just try, your success, relation 5, is really low compared to the success of actually shooting someone with a gun. So in the relevant sense of control, I don't even think there's a degree difference between the degree to which you control this and the degree to which you control that in the ordinary sense of control. In which event you cannot found a moral distinction on a difference of capacity that doesn't exist, nor do you want to say that the law is wrong, because somehow we can be blamed for the first, but not for the second. If you can be blamed for your intentions, my conclusion, you can be blamed for your results. In the relevant sense of control, you control both. What do you think about that?
I think that one thing about this chapter of the book is very central, and I think that you make here an argument that you don't take so seriously in the other chapters of the work. So perhaps I will anticipate some discussions, but I think that it's very important to, because you, in this argument, you sometimes affirm that you think that causation is the first principle of morality, and I think that has to be more consequence that you allow in the rest of the book. But for example, I think that your argument here is that your argument against the control theory is that theory is self-contradictory, because in that sense of control you can't control nothing. I think that
in that branch of the argument, that's right.
So I think that, for example, for the first version of the theory, you say, well, you cannot, in all the steps from character to result, you can generalize your sense of not controlling. So you cannot control the result, but you can control the bodily movements, etc. And I think that argument is very compelling, because you can make the contrast between that version and to the execution intention. Because I think that the argument of the execution intention can be based in the distinction that you make also between irate judgment and ecological judgment. The coupling between the step 3 and the step 4, you can say ecological judgment are based on intentions. When you judge not the character of the person, but only what that person acts in the past, you are only judging from the step 4 to the step 6. So I think one complementary argument that you can make is that against the version of the executing intention is that that theory also is self-contradictory, because the only gap you can make between the bodily movements and results are that you can control preemptive causes that are coincidences, or what Locke names vis major, or acts of God. Mm-hmm. So, which are cases in which you, for definition, cannot control
and for which you are not blamed, either in law or morality, right? Because they're not proximate causes.
So you can make the same argument, the self-contradictory, because for definition they require that you can control preemptive causes that are normal causal forces.
Now, I'm actually unsure whether you're agreeing with me or not.
Yeah, I agree with, I'm so agree with this chapter, but I think that you don't take it seriously.
I'd like to hear about that too, but I'm curious. I mean, it sounded to me like you agree with the chapter, which is take two senses of control. In the stringent sense of control, it's true you don't control results, but you don't control anything else, so nobody's blameworthy for anything. In the non-stringent sense of control, you control all of this, but in that sense of control, you control results. In a nutshell, that's the argument of the chapter. And I gather you agree with that. I'd be curious what you think, how I abandoned it somewhere else.
Well, I think that your argument is that it's very similar to Strossen in this chapter, in the argument that Strossen is making freedom assessment. If you don't believe that causation matters to responsibility, you cannot explain our basic intuitions about morality, and you cannot explain how do we live in the reality. That's, I think you have to review all your first intuition, and you have to review your more basic beliefs about moral responsibility and about how the law works. I think that's the bedrock of your argument.
Yeah, I'm not a Strossonian in my meta-ethics, although that's kind of by the by, I think. I'm not an expressivist. I actually am a realist in ethics. But here's what I would take from what you just said. It is interesting to ask me, what do you think you've established with this argument? And the actual conclusion is actually more modest than it sounds. Because as I think you said earlier, conceding that the book I was criticizing makes it look like you have more control in my sense than you do with regard to these items, these relations. I don't think I've given you a reason yet to agree with the conclusion that causation matters. All I think I've done is say you can't draw a difference if you've got a reason to think, as I think you do, that your real desert basis is just here. An arguable interpretation of Kant, for example. It's not executed intentions, it's just intentions. The only purely good thing is a good will, the opening lines of the groundwork, right? If you interpret that to mean the only thing that really makes you blameworthy or praiseworthy is the intention you formed, I haven't said anything that rules that out. Notice the context of the argument as I was presenting it. All I'm trying to say is the John Elsters of the world, and all the others like them, who think they have an argument I don't have it. If you want to defend Kant on intentions being the locus exclusively of blameworthiness, that is open to you. But not on the basis that you control these more than you control these. Now we need some independent basis. Some basis for arguing, why is it intentions that are the desert basis? Or if you like, why is it that it's intentions that are the objects of categorical as opposed to erotaic obligations, the way you started? Argue away, but it won't be based on control. I don't have a control argument for why you're responsible for results, but I'm honest. I don't have an argument. All I'm trying to get is equal honesty from others. They don't have an argument why it's intentions. Aristotle doesn't have an argument why it's character. Alexander, Frozen, and Morse don't have an argument why it's executed intentions based on control. That leaves all other possible arguments open. It just means control is not the argument that anybody gets to use to pick what's the desert basis. The objects of categorical obligation or other desert basis for blame. That's all that this argument is designed to show. More modest than it looks. The next clump of the chapter I want to go to is what kind of argument you can make. This argument is just to say, my opponents are just as poor in argumentation as I am. I call it the parity and poverty of argumentation. But let me tell you how contentious that is around the world. The other people on the other side of the street, I've never seen one of them fess up on this issue.
In which sense you could say that Freud is like we are morally responsible for X. This premise is false or true.
Do you say for X, a variable X?
Yes.
Yeah.
But this, I mean, from what depends the truth, the truth or the truth or false character of this premise? It depends on moral reality or something like that. But in your argument, there are a lot of mentions, a lot of uses of little bit or not little bit different argument. It's not an argument who refers to a moral reality, but who refers to idiomatic uses of the terms, of the term control, of the term responsibility, etc.
Sure.
And it depends on idiomatic uses, ordinary language. It depends on real moral wall or something like that, or which are the relationship between this and these two type of arguments.
Yeah, but notice my reliance on ordinary speech was just to get clear a hidden ambiguity.
What is the relevance, the role of an argument based on idiomatic uses if we have moral correctness, objective moral correctness?
Well, 2 points. Look, the argument from idiomatic usage was not of a Straussonian or any other kind saying the condition for the possibility of our using language this way is X, Y, or Z. It was simply to say, in the argument of my opponents on this issue, there is a hidden equivocation on control that, if not addressed, makes their argument fallacious. That if you make it valid by univocal usages of the word, it is valid but false because of the falsity of one of the two premises. That's the only way I use it, but notice how modest I am. I haven't made an argument yet. Now, the second point is this one. You have, I gather, noted that I defend moral realism in metaethics. But look, let's not get the metaphysics and the epistemology mixed together. That I'm a moral realist does not mean I have some special access to the moral reality where I can grab it and say, there, look at that. I have to make arguments like anybody else. Moral realists, unless they're strange sorts of foundationalists with an epistemology of direct access to the reality, have to make arguments like anybody else. So what kind of arguments would I make? I haven't made any yet. What would I make? Well, it wouldn't be moral reality says. That would be the conclusion. Here's why I think moral reality does not make Kant right about intentions being the exclusive desert basis. Here we go. Try this one. So remember when the Frankfurt police chief was retired early about 7 years ago because he had threatened to torture a terrorist who had kidnapped the 12-year-old son of a German industrialist and had buried the son underground with not enough air. And the police chief ingeniously said the following, something like this: there are not very many advantages for Germany having a Nazi past, but here is one of them. I have on the plane from Dusseldorf one of the old Nazi Gestapo torture specialists who can cause pain like no human being can cause on earth. He will be with you shortly. You can tell me where the kid is, or you will tell him. Now, he said he wasn't idly threatening. He said, I intended to torture the police chief. He was honest. It turns out the threat was enough. The person who buried the kid said where he was. They dug it up. Unfortunately, they weren't quite fast enough. The kid actually had suffocated to death. And the police chief was involuntarily retired for intending to torture. Now, A view, I suppose appropriate for Germany if you believe the old Königsberg philosopher, a view could be you are categorically forbidden to intend to torture. It's a possible moral view, one that would give rise to intentions being the desert basis for blame. I just think it's wrong. I thought the police chief got it right in intending to torture and communicating the intention, because had he saved the kid, it wouldn't be that he tortured, he simply intended to torture. Imagine I know that you will restrain me from my intentions. There's an intentionometer on my head where the light goes off if I form the intention. I can get really good consequences from intending to torture, but I know you'll prevent me from torturing. What kind of a morality would forbid me to intend to torture when I know I can't carry it out? What harm is there in my intending to torture when I can get good consequences? It's not contradictory, it's just wildly implausible. So my conclusion about moral reality is, not because I just plucked a piece out of the sky, as an inferential argument on the structure of morality coming from a substantive moral intuition, namely the police chief got it right. I infer that you do not have, as the objects of your categorical obligations, not the forming of intentions. I conclude, actually, the object has to be more complicated than that. But notice, that's a substantive moral argument, depending on you sharing with me an intuition that, incidentally, most of the people in Frankfurt, except the ones in charge of the chief's career, happen to agree with. But I don't raise their agreement as a matter of convention. That's just social belief. I raise it for the epistemic evidence that reasonable people's beliefs sometimes are, namely some people sometimes know things we don't, and sometimes if they say, I think X, that's a reason to believe in X.
Let's just you some clarification about about how this scheme and this idea, this understanding of control can be applied for judgment of moral responsibility. Because I see your presentation of these issues as partial, and in a way, I'm curious to know what would you say, including also other aspects you are not mentioning, and which are, I think, part of our conception of moral responsibility. So, I mean, it's a clarification about your moral philosophy, your ideas about moral responsibility in particular, because I mean, I found it partial. First of all, because it is a scheme based on law, and so it's a scheme in which moral responsibility is relevant about blameworthiness and not about, for example, praising someone for something and some results. So in this sense, I find it partial. And but let's take, well, I mean, that's okay for me. Let's talk about only about blameworthiness. But even talking about blameworthiness, what would you, don't you think that this understanding and this view about the meaning of control and how this reference to control can lead our judgments on responsibility? Don't you think that this understanding take only into consideration, is only useful for judgments in which other people judge our actions, and not which are a big part of moral judgments of our responsibility, but that they are not the only, because there are also, I think, in judgments of our moral responsibility, there is also another big area of judgment, which are judgments on ourselves, judgment on our actions. And I wonder whether I would like to know which are your ideas about this other area of moral judgments, because I think that in this other area of moral judgments, which is, I think, an area of moral judgments, a relevant area of moral judgments, I think that the issue of this understanding of control is much more complicated, and because I can see the situation in which I can understand the sense in which this scheme of control has to be applied when other people are judging us, are judging me, for instance. But when myself, I'm judging myself for something that would happen or for some results of my action. I'm referring to the idea of agent regret, Bernard Williams' idea of agent regret, which is one of the bases of this discussion of moral lack. I think that there is something that this scheme of control cannot explain or is not able to solve. What do you think about this?
Well, remember, I don't make an argument based on control. All this chart does is show a parity of control in either of its two senses across all possible desert bases. That isn't an argument. That just says there isn't an argument based on control. That's what that does. So I don't have an argument based on control. It's an argument against there being an argument based on control is what this is supposed to do. Now, you do invite me very kindly to expound on other things, so I will. About the praiseworthiness, blameworthiness, asymmetry. It's an interesting question, books like Leo Katz's Ill-Gotten Gains. He thinks there's a symmetry, and there's certainly some symmetry between the conditions of praiseworthiness and the conditions of blameworthiness. In law, that's the parallel between Lockean natural rights theories of properties, where if you invest your labor in a thing intentionally and bring about the new thing, you cause it, you're entitled to a natural right in property, whereas if you cause something bad, you're entitled to punishment, i.e. you deserve punishment. Those are affinities between natural rights and retributive and corrective justice theories of property, tort, and criminal law that I do think exist. I'm not committed to there being a perfect match between doing good things and getting rewards and doing bad things and getting punishments or sanctions in tort. There's certainly a parallel. But you kind of put that aside, so I will too. You then suggested there is a difference between first and third person moral judgments. And you went to what you feel in terms of Bernard Williams' agent regret. Now, most people think agent regret is a perfectly psychologically familiar phenomenon, and in the hands of a lot of people, a morally compelling one. You should feel it. A decent person would feel moral regret for consequences they brought about even inadvertently, for example, which is what Susan Wolf thinks in the article I talk about in this chapter. I am curious whether you think the truth conditions of a moral responsibility judgment differ in the first and third persons. So suppose, to take Susan Wolf's example, you're driving a truck through Girona, make it a little too fast so you're culpable, a little bit, negligent, and a child darts out which you run over. You wouldn't have run over had you been driving slower. You could have stopped, but you couldn't stop because you're going too fast. So you culpably cause the death of a child. Presumably you feel some regret about that, some agent regret, but before we get to the details, I would blame you for that. You would blame yourself for that. Is it possible the truth conditions of a same judgment, if uttered in the first and third person, would be different? It makes for a very odd morality. My sense is the answer to that is a resounding no. There's an old example in philosophy, it's not in ethics. It was Wittgenstein's theory of mind, where he said there's a difference between first and third person utterances of things like I am in pain. In the first person present tense, Wittgenstein said, I am in pain simply expresses pain. It's like saying ouch. But in the third person, he is in pain actually describes a state the person is in. I think you have a really hard time making language do that. I think the first and third persons ought to have first and third person expressions of the same proposition, different pronouns, same reference, ought to have the same truth condition. So I don't think there's a first and third person difference. I think what you've got is the sense of many moral people. They hold themselves to a higher standard than they hold others, not because at the end of the day we really think the truth conditions of those sentences are different, first and third person expressions of them. It's just because as a matter of, it's almost arithmetic. You're a better human being if you're more stringent with yourself than you are with others. You're a worse person, archaically, if you're more stringent with others than you are with yourself. But I don't think the truth conditions change. Anyway, agent regret, last point, is really different than blameworthiness. Agent regret is something, look, I feel regret if I cause a harm that I'm not blamable for. If I innocently cause a harm, I think a decent person has some real regret about being the agency that in fact made the world worse, even though I wasn't negligent, couldn't have foreseen it, didn't foresee it, certainly didn't intend it. I think you're a better person if you do feel regret. That doesn't mean you are blamable. So you can have, I think, the feelings you do, but you don't have to have the extreme of thinking there's a first, third person asymmetry in the truth conditions in the sentences expressing moral judgments to do that.
I want to point out that you have two strategies of argument in your book. One of them is showing how believing that causation matters to moral can explain some distinctions that we make. For example, in allowance or preventions, you permit the use of consequential justifications in a way that you don't permit to causation cases. I think that that's a very good strategy which is based on the capability of your theory to explain the descriptive metaphysics that you develop in your book. I think that, but as you say, against for example, the approach of the ordinary languages theory, is that the plain man view supports something that doesn't necessarily end the argumentation. We need some more justification that we make ordinarily is really just or has justification. So, and besides the argument that your theory explains better some distinction we already made, your argument in this part of the book, and for example, when your argument you're making your argument about the moral importance of the counterfactual dependence in the judgment, you also appeal to the intuition of difference. Another crucial part of your book when you make this point that the first experienced person view has an epistemic value. And I think that the problem is that methodology, in the point of view of the methods, your book make an argument too strong against the ordinary language program, which is that the plain view man, that's your argument, has an Stone Age metaphysics. So it's kind of, you need to go to metaphysics and scientific view because to trust in the plainsman view is to trust in the, using the Austin words, is to trust in the Stone Age metaphysics. But I think that that's too strong because from a realist point of view, you can explain why prima facie the ordinary languages distinctions are important. Because, for example, I think that moral realism puts more charge on justification than if you are not a moral realist, because you have to show that for every moral distinction, you have to show something that appears to be a real property. With a symmetry that not every real property makes a moral difference, but for every moral difference, you have to show a real property. And for example, in the case of ordinary language and law, which tracks down very closely, as you point out too, the plainsman view, the ordinary language is formed from the everyday dealing with reality. So we make linguistical distinctions in dealing with moral cases from from the plaintiff's point of view, and you can know how without understanding why you make it. For example, for almost every legal doctrine that you declare to be wrong, you declare to be wrong because it's only a proxy that is taken as a categorical distinction, or because mistakes a culpability judgment for a causation relation. So you almost say everything about the actual legal doctrines except what they say about them, what they are. I don't know if you understand why, because you are so good your book in the metaphysics, in the descriptive metaphysics, that betrays your methodological affirmations against, I think, a well-founded phenomenological argument in favor of ordinary language, or a strong like the strategy.
Well, thank you for reading so much of the book. You picked and chose from various parts very nicely. Yeah, I believe all the things you said. That's true. I don't think that commits me at all to the ordinary language program. It's not just realism, to go to something else, it's not just realism, it's a naturalist realism that you were picking on. Namely, supervenience for a naturalist is that you require for every moral difference a natural difference, although not vice versa. That is true. That doesn't mean that for a believed difference, that is a psychological difference, there has to be a moral difference. That certainly doesn't follow from any meta-ethical postulate or premise or approach that I have in the book. If people have some believed differences, I do exactly what I was just saying to Jordy a moment ago. I take it seriously in the sense that it's a heuristic, a learning device. It's possible they see something I don't see, so maybe I should take seriously that people really think there's a difference between allowings and doings and allowings, for example. It doesn't mean there is a difference. Ordinary language philosophy was different. For those of us who grew up in it, it went like this. Before 1965, Gilbert Ryle, Wittgenstein, Hampshire, and J.L. Austin all had the following to say about the theory of reference. Reference questions were out of bounds with regard to categorical conjunctions that made no sense. And you could see the categories simply by looking at patterns of ordinary speech. So to take Ryle's famous example in the Concept of Mind, Chapter 1, you can see the patterns of speech for the body differ from the patterns of speech of the mind. And therefore, you can't ask questions of reference and identity about mental words because it's out of bounds linguistically. That's the Stone Age metaphysics. That's to try high-handedly from the armchair to answer the questions of deep reference of terms like intention, as opposed to actually doing the honest science and saying where in the brain might it be located and how does it correlate with the phenomenological and behavioral evidence for it. There's nothing in my book that I think goes back to the ordinary language program circa 1950 in that sense. I do take seriously the distinctions other people draw, and I take seriously the distinctions the law draws as well. There's a lovely line from J.L. Austin, not one of my methodological heroes, but it goes something like this. He says, "It is amazing how instructive it is when you're doing ethics to pay attention to the law." Just the straight law, what the judges are doing in cases and doctrines. Not because the law gets it right all the time. It's rather, he said, as a thought experiment, here's what you get from the law. One of his famous aphorisms was, "The law is richer than diction." Namely, the variations in factual patterns that can occur outstrip the ability of our stated speech in an amazing way. You end up with hypotheticals you couldn't think of, and if you study the law, you end up with resolution of those by people who are uncluttered, unspoiled by philosophical theory, because judges don't know it typically. And even better, you end up with a judgment of someone who actually has to attach real-world consequences to their intuitions, unlike us armchair philosophers. Remember the old Samuel Johnson line, "Nothing so focuses the mind as being prospect of being hung in the morning." Well, a decent judge would put it this way. Nothing so focuses the mind but the prospect of hanging someone in the morning. If your distinctions on moral luck make the difference between somebody being hung or not hung, I trust your intuitions as being a really honest effort on your part to figure out whether this makes a moral difference or not. So, lots of reasons to pay attention to what people believe, and particularly what lawyers believe when you're doing ethics. Of course, it doesn't mean at all what they believe is constitutive of what's right. As a realist, you separate convention from reality continuously. So I don't think there's any methodological description. You could call what I do descriptive metaphysics, which was Strawson's old term, where you're not committed, but you're simply describing a set of phenomena that other people believe and asking what are the metaphysical presuppositions of that phenomena. I don't intend it as that. I intend actually to present conventional beliefs, legal rescissions, and the like as thought experiments with which, if you're like me, you agree with them, you find them intuitive, then you can draw the inference that maybe indeed moral reality licenses those distinctions. So I'm not simply doing what I regard as the shallow metaphysics of Strawson. I actually intend to take that as the inference base, the basis for an inference about what really lies in the depths of moral reality. So not quite as modest, I think, as that. But anyway, thank you for reading so much of the book. That's a lot of different chapters you went through. I don't know how long you want to go. I can talk forever, so tell me how long you want to go.
1.5, maybe 20 minutes.
20 minutes more?
20 minutes
Okay.
more.
Here's my proposal. How about a few minutes on the argument I do make in the chapter and in the other chapters about why results matter. I do try, as you pointed out, to make an inference from first-person experience to what's true about blameworthiness. And it actually is a personal argument, and I won't give you the personal history because why should you care, but here's how the general form goes. If you've ever really culpably caused harm to somebody, if you're a decent human being, it eats at you through guilt in a way that you do not feel if you were equally culpable, but you didn't cause the harm. You didn't run over the kid, although you were drunk as a skunk driving through a neighborhood too fast and so forth. If you did run over a kid, there's a guilt that eats at you that does not eat at you if you didn't. I argue in the earlier book and repeat in this chapter, it's not just that you have the feeling that's the basis for the inference. There's also a moral pedigree for the feeling, namely morality is complicated. I use errataik theory as a touchstone of epistemic insight for deontic theory, namely, I say if it's virtuous to feel an emotion, that is evidence, but far from irrefutable evidence, of the truth of the judgment to which that emotion leads. So that if you go to a poor country and feel compassion for the poverty of the place, if it's virtuous to feel compassion, that's evidence for the truths of distributive justice to which that compassion leads. And the same, I think, is true of retributive justice, and the same is true about the degrees of blameworthiness for causation. So, we feel a lot more guilt if we cause harm than if we simply risk it even culpably. Second, the guilt is virtuous. I know Nietzsche thinks guilt is a useless passion. It's always after the fact. I don't think so. A moral human being feels guilty for things that, in fact, are blameworthy. You don't have a don't cry over spilt milk attitude, even though Nietzscheans think you do. So you do feel guilt. It's virtuous to feel the guilt, from which I draw the inference. The judgment to which the feeling leads, namely you are more guilty, is true. That's not ineluctable. Herbert Morris has a lovely essay called Non-Moral Guilt, where he details how various situations like survival guilt and others, we feel the guilt, it's probably even moral to feel the guilt, and yet you can't draw the inference you are guilty from the feeling. So it's not an ineluctable inference, it's simply an inference. It's a very short argument chain, but as I say in the book, the older you get, the shorter become your chains of arguments in philosophy. And I'm getting to a point, but at some point I may just skip the argument altogether and just state the views. But I do think there is an argument that once you feel its power, the rest seems by the by, which is why I'm so dismissive of my colleagues who argue for the same conclusion in these 12 arguments we didn't discuss. That's an awful lot of clever argumentation, all of it fallacious, arguing for what I know they believe on instinct anyway, the old F.H. Bradley line. Much of ethics is finding bad arguments for what you believe on other grounds. The ground on which I actually believe that results matter is the inference from guilt. Live long enough and cause certain sorts of harms, I find those to be very compelling sorts of inferences. That's what's called the phenomenological argument. I know that John Gardner at Oxford is writing a review for legal theory, which he's going to give in Germany at another conference on the book. Criticizing that, I'm curious what John's going to say. But John's like me. He believes that you are more responsible for results, so I'm curious to see whether he's got a different argument for that other than the one that I know he's going to criticize. But that, in a nutshell, is the source of the argument. There's a set of others that I make, but that's actually motivationally the one that does it for me. Let me just say a little bit about the next chapter, because that's kind of fun stuff that we might have a bit of time to talk about. In chapter 3, I use causation as the license for permissible consequentialist calculation. It's kind of a mouthful. I use it to analyze what the doing and allowing distinction, the 1,000-year-old companion of the doctrine of double effect in Catholic theology and contemporary moral theory, is actually up to. So I'm curious what you think of some of these sorts of examples. The ones from chapter 3 that I go through, I said there's 6 of them. Let me just see what you think of some of these, because they're kind of intuitive. I present them again not because I'm doing descriptive metaphysics, but rather because if you agree with the intuition I have about these cases, isn't the role of causation that I chart in the chapter the best explanation for why indeed you have those intuitions? That's the nature of the argument. So take the act-omission distinction, where you do an action causing a harm versus you fail to do an action that, had you done it, would have prevented the harm. That is, you omitted to do the harm. Since I think, and argue here and in other books, that omissions do no causal work, that is a causal distinction. Is it morally compelling in the way that I say that it is? Namely, you can justify with good consequences an omission in a way that you can't justify an action. Typically, people teaching torts and criminal law talk about people in lakes and so forth. We'll do that, but let's get on to something more interesting. So, there's some people in a lake. There's one group over here, and there's another group over here. This is one person here and 5 over there, and you've only got one rope. And they're going down for the 3rd time, so you can only save one group or the other. If you throw the rope to the 5 and save them, you will have omitted to have saved the 1. Can you justify omitting to save the 1 by the good consequence of saving the 5? Every person I've ever talked to says yes. Suppose that is true for you too. Then the contrast case. There's 5 over here drowning and 1 over here drowning, but the rope has already been grabbed by the 1. And he is pulling mightily but slowly up the rope, and the only way to save the 5 is to take out your pistol and shoot him off the rope and then throw it to the 5. Can you cause his death in order to save the 5? Can you justify good consequences? Can you justify the prima facie wrongful action of causing his death as opposed to failing to prevent it with good consequences? Most people have some resistance to shooting him in order to get the rope. Try a real-world example. So, Winston Churchill says in his memoirs that he got the news 3 minutes after Hitler made the decision that they were going to bomb Coventry and dispirit the British people by civilian bombing. He got it in time to have evacuated the city if he wanted to. He didn't evacuate the city. He never said a word to the citizens of Coventry because he didn't want to reveal to the Germans that the British had got an ultra device, the German coding device of World War II, because that would in fact make the war longer and you'd lose more lives. They had an argument in the British War Cabinet. The socialist minister said, "Winston, you're playing God," and Winston said, "For good enough consequences, I will fail to prevent the citizens from dying, but I won't be killing them. The Nazis will be doing that." Suppose the situation presented was different. Suppose it wasn't an omission to save the citizens of Coventry. Suppose it was this. One of the citizens of Coventry had discovered that the British had the Nazi ultra device, but you don't know which one. Could Churchill have ordered the execution of the citizens of Coventry to prevent the Germans from learning that the British had the ultra device. Same good consequences, but now, of course, it's an act of killing rather than a failure to save. Could he, in fact, have killed the entire populace instead of simply failing to prevent their deaths with the same good consequences? I take it Churchill would have not said, I can shoot them all to prevent the one, whoever it is, from divulging the secret. Now that looks to me like a causal distinction. If I cause the harm, good consequences can't be used to justify that causing. But if I merely fail to prevent the harm, they can. So I call those cases of omissive allowings. And then there are 5 cases of non-omissive allowings, where you allow but do not cause the harm. We'll try a couple of them at least. Yeah.
In general, I have some problem in seeing omissions as non-causal actions. And so in general, this is my point of view. So I would like to ask you if you find some difference in modified version of one of these cases. If, for instance, there is always the case in which there is one person running and 5 persons running, and let's say not saving or not saving in some way the one person running, you save the 5 persons running. But in the 2 situations that you presented, the one in which you just omit to save, or in the other in which you kill the one person running, because killing this person you find a way to save the other 5. In these situations, you are happy about killing that person, which is your worst enemy in the world, and so you are happy not saving him, or you are happy killing him. Would you find any difference in this situation? I mean, because I think that because my idea, my feeling, it's that there is something linked to our judgment about intentions, which leads our judgment about omissions and action and difference between omission and action. And I think that in this case, if you suppose that in both cases you are happy, you are very happy of not saving or of killing. I mean, maybe it's even better killing in that case if you are not happy. If you are happy of that is my feeling, and so. No, it's the right kind of challenge, which is okay. Take the paired examples and add another factor and see if it in fact evaporates the difference I claim exists. The factor you add is the evil person who's happy either at omitting to save or at killing one or the other. Yeah, or the good person who's happy to kill the evil one.
Before I give you the general answer, try this one. Suppose you want to kill me. I'm actually a much better shot than you. I know you don't have a chance. So I say, yeah, you really want to kill me, right? That's what you want to do. I want to make this absolutely plain. I've always wanted to kill someone myself, but I don't want to go to jail. But there is this thing called self-defense. I am really happy that you want to kill me. Go ahead and try. You try and I shoot you dead. Do I not have a justificatory defense of self-defense just because I'm really happy that you're coming at me? The famous American film, of course, is Charles Bronson's Death Wish. He's really happy they're coming at him because he flashes a big wad. He's a vigilante. He wants them to come at him. But suppose Charles listens to you and he says, well, look, I'm really happy. I've always wanted to kill some people. Here's my legal privilege. They're trying to kill me. And he says, you are going to kill me, right? That's what you're going to do unless I shoot you. And they say, yes. And so he kills him. You think it affects at all his defense of self-defense, that he's a happy self-defensive killer?
No, I don't think that it is.
Yeah, well, you don't, and I don't think happiness makes any difference on the act-omission distinction. So suppose you are delighted your old enemy is drowning. You still omit to save him, you don't cause his death, and the same good consequences really exist even though it makes you happy to throw it to the 5 because you don't have to throw it to your old enemy. It strikes me your happiness is irrelevant to the justification, just like it is in self-defense. And with regard to the happiness of the killing, It makes you somewhat more odious, archaically, to be a happy intentional killer rather than just an intentional killer. And perhaps that can enter in when we get to sentencing. But in terms of the basic conditions of liability, morally or legally, you're an intentional killer. And you're either justified or not, and I take it not because you're a killer rather than an omitter. So I don't think it makes any difference at all. Now try some of the more subtle distinctions. I think act omission's kind of crude. If you look at the literature on doing and allowing, particularly Frances Cam, who I know is unreadable, but she's worth reading. It's a very high-density material. She was my commentator on an earlier book on action theory, where she did the act-omission distinction, but particularly doing-allowing. Her analysis, along with people like my former colleague Jeff McMahon, the Big Fat Killing book, goes something like this. There are allowings that are not cases of omission, because you're doing something. You're actually acting. Passive euthanasia, for example. When you turn off the machine, it is not an omission, even though the English cases say that it is. That's just an abuse of the word. But it is, in the right circumstance, an allowing. And on Cam's and McMahon's and other ethicists' analysis, they call it removing a defense to nature. What you did was remove a defense and let nature take its course. Namely, the person was a dying person before you hooked him up. When you unhook him, you return him to the natural baseline from which your intervention began, and now nature takes its course and he dies. You only allow him to die, as opposed to giving him a lethal injection, which is an active killing, active euthanasia. So we have doing allowing in this instance of the passive euthanasia cases. It's much, much broader than that. Chris Bourse, a friend of mine who taught at Delaware for years, gave this famous article called Ducking, the ducking cases, where in the example that's descended, as I say in the chapter, to the level of cocktail party conversation, you and I are camping, and here comes, we're in Alaska, the big grizzly bear that's going to eat me, because I'm closer to him. But he's a little slow, so I get time to put my Adidas running shoes on. And you shout to me, you fool, you can't outrun a grizzly, because they run faster than people. And I shout as I run past you, I don't have to outrun the grizzly, I only have to outrun you. Can I justify allowing the bear to kill you in a way I couldn't justify shooting you so the bear feeds on you to slow the bear down? Many people find in those ducking cases the intuition, like in the passive euthanasia cases, I can justify that by the good consequence of saving my life, ducking in the proverbial sense of letting the bear take you, or letting nature take its course in the case of unhooking a respirator, when I couldn't justify either active euthanasia or actively handicapping you so that the bear can get you. Now, what's the actual metaphysical structure of those cases? It's two parts. One of them is, it's not a causal structure. These are what metaphysicians call cases of double prevention. What I do is prevent a preventer from preventing the harm. So in the case of unhooking the respirator is preventing the death of the patient. I prevent that preventer from doing what it's supposed to do, which is preventing the harm. Metaphysically, what I've got is prevention of a preventer, not a causal relationship. That is a contentious metaphysical issue on which I and a bunch of people agree, and lots of people disagree with us. But so far, removing a defense to nature is non-causal. It's counterfactual. But for my removal, the person would not have died. That's true. But nonetheless, it's not causal. So it's non-causal, and here's the second part, but it returns the person to an appropriate moral baseline. Namely, if I'm your only defense against the grizzly bear, I am entitled to return this to the natural state, which is I'm not the defense, you're facing the grizzly bear on your own. If I'm the doctor who's hooked up the patient to the respirator, I, but not a third-party intruder, am entitled to return to the baseline of the patient unhooked, if I have good enough reason. In which event, an allowing is a metaphysically double preventionist counterfactual dependency that is not causal, but also returns the person who is injured to the state he would have appropriately been in had there not been an earlier intervention, or in the case of the grizzly bear, that I'm entitled to return to even though there's not an earlier intervention. I call this the appropriate moral baseline. Now, that's a complicated structure, but I find it very intuitive to think it makes all the difference in the world whether you cause or merely allow a certain harm. So take this kind of case, actual American case. There was a judge in Alabama who was happy that his neighbor in another town was going to get killed by 5 brothers because the neighbor had seduced the judge's sister-in-law. Not raped her, consensual sex, but seduction. This is 19th century Alabama where they took this stuff seriously. This is not 21st century California. So, he's really happy that these guys are going over to kill this guy whose name is Ross. Then he becomes unhappy because he learns that the local telegraph operator has sent a warning telegram warning the victim that the 5 skeleton boys are riding over to kill him, and the victim will get away and he won't get killed. So the judge uses or abuses his position to get the telegraph operator to send a countermanding telegram to the other town so that the operator in that town will not deliver the warning message. The operator doesn't deliver the warning message. The skeleton boys find the victim and they kill it. And the question then is, what's the blameworthiness of the judge? It's an accomplice liability case. Now, that's not yet an allowing case because notice the judge isn't returning to an appropriate baseline. He is a double preventionist. With the countermanding telegram, which is an action he's doing, he is preventing a preventer, the warning telegram, from doing its preventing work. The death of the victim counterfactually depends, but is not caused by, the judge's action on the metaphysical view of causation this book defends. Now make it a true allowing case, add the second feature in. Suppose the warning telegram had been sent by the judge, and then he thought better of it. He says, I don't want to warn that guy, I want him dead. So he countermands the warning telegram with the second telegram. If he is entitled not to have sent the first telegram, the warning telegram, it now becomes an allowing case. He allows the death by removing a defense to that death that he himself provided but was entitled not to. In which event can he justify, with some good consequence you can just have to imagine at least, the double preventionist allowing of a death? The argument of the book is he could. But allowings, like passive euthanasia, the Bear cases, Judith Thompson's famous violinist case, or this case I just gave you about the judge, are all cases where, since you don't cause, and since you do return the person, the victim, to an appropriate baseline where nature can take its course, you can, as the Catholic Church has said for 1,000 years, allow his death and justify that in a way that you could not justify causing it. That's a second kind of causal license, making permissible consequentialist justification when otherwise it's impermissible. Complicated structure.